and welcome to the BLC Digital Studios. My name is Charles Bonani. I am an associate attorney here at Berenzweig, Leonard. I focus mostly on government contracting matters, as well as employment litigation and other related matters that arise. And I'm here with my colleague, Rachael Haley.
Hi, as Charles said, my name is Rachael Haley. I am a senior associate here at Berenzweig Leonard. I mostly focus on government contracting, but do some business litigation as well as some employment litigation.
Okay, well, with those introductions out of the way, we will jump right into why we are here today, why we are sitting in this beautiful, beautiful studio. So today we are going to be focusing on bid protests. In particular, we're going to be focusing on the most common evaluation and award decision arguments that contractors can make when they have unfortunately found themselves on the wrong side of a award decision. Rachael, why don't you start us off a little bit with an overview of this discussion?
Absolutely. So, as Charles said, we're going to be focusing on bid protests. A bid protest is a challenge to any procurement action taken by the federal agency. Today, specifically, we're going to be talking about post-award protests challenging the agency's evaluation and ultimately their award decision. Just for clarification, we will not be discussing pre-award protests or size or status protests, which are going to be filed with SBA instead of the normal bid protest venues.
Yeah, there are a lot of collateral considerations and matters relating to the bid protest world, and as much as I know you all want to hear about all of those will be saved for future podcast endeavors because we only have a limited amount of time today. So I'll start by talking briefly about some of the preliminary considerations information regarding bid protests. So one first piece of information to highlight is where you can actually file a bid protest. And there are three different venues that those can be filed in. They can be filed directly with the agency. They can be filed with the Government Accountability Office, which we will be referring to as the GAO throughout this podcast. And they can also be filed in the U.S. Court of Federal Claims.
Yeah, and so generally, which venue you want to file in is going to be very case specific, but with respect to post-award protests in particular, the vast majority of those are filed with GAO in order to utilize the Competition and Contracting Act stay process that GAO allows for.
Yeah, there are a lot of nuances there to consider, which, again, you might hear me say a few times throughout this are outside the scope of this podcast. So we'll keep it moving with that. You might be wondering, can I protest? Who can protest? For these, generally, protesters will be unsuccessful offerors in a procurement matter. And you have to be able to show that you were prejudiced, broadly speaking, which generally means you were harmed by the improper action taken. So it's not enough that the agency erred in some capacity. You have to be able to show that you were harmed. And then getting into a little more specifics with that, you have to be able to show that you were an interested party. So in this evaluation and award context, this means that you were an unsuccessful bidder who had a substantial chance of award. And is there anything else that I might be missing there, Rachael, that you could fill us in on?
Yeah, it's important to understand what substantial chance of award means once it's actually applied by GAO and the Court of Federal Claims, and really that ultimately requires the protester to be next in line for the award. So if you were the second ranked offeror, like that is, you have standing to file that protest. If you happen to be the third or fourth ranked offeror, you can still have standing to protest, but you are going to not only attack the award, but you also have to attack the evaluation of all of the offerors that are ranked higher than you and are in your way to award, so that you have to show that you have that substantial chance of award. So whereas if you're second in line, your standing requirement is a little bit easier. Your substantial chance of award is pretty clear on the face. Obviously, if the awardee is knocked out, you are next in line. If you are further down in the rankings, you're going to have to do a little bit more argument and attack not only that award, but also all of the offers between you and the award.
Understood. So as basically what you're saying is the farther away you were from obtaining the award, the more work you're going to have to do to get your foot in the door.
Yep. Yeah.
Okay, that makes sense. So moving on to how long you have from your notice of being an unsuccessful awardee to actually filing. This is a very important point because to get to the nitty gritty of it, the process moves very fast. It is an incredibly quick turnaround time from when you will receive notice of the award to when you actually have to file a bid protest. So because of that, it is important to be primed to recognize what your potential bid protest arguments might be so that you can initiate conversation with counsel and have those particular discussions ready to go so that you can make a decision very quickly on whether you want to turn around and file a protest. So the GAO in particular doesn't make it too easy on would-be protesters, unfortunately. So we'll move on now to getting into the actual specific protest arguments. And to set the stage a little bit for that, we thought it'd be helpful to provide some of the statistics that the GAO keeps on the annual protest ground. So the GAO actually is required by law to provide annual reports to Congress on the general protest landscape and specifically which types of protests were the ones that were most sustained. And if you are so interested, you can go to gao.gov and look at those reports yourself. In the fiscal year 2023, the most commonly sustained bid protests at the GAO were number 1, an unreasonable technical evaluation, number 2, a flawed selection decision, and number 3, an unreasonable cost or price evaluation. And in fact, over the past 5 years, in each of those 5 years, an unreasonable technical evaluation was the most commonly sustained protest. So given that, we thought it would make sense to start with technical evaluation challenges. Not only are they the most common, but I would say, Rachel, they're probably the protest ground that has the most ground to cover, for lack of a better term. Would you say that is fair?
Pun intended.
No, yeah, I guess so. We're already doing puns.
Yeah, I mean, it's definitely the most comprehensive protest ground. There are several different varieties. It can attack the evaluation of the agency's technical evaluation, the agency's past performance evaluation, the agency's cost and pricing evaluation, and not only just the reasonableness of their evaluation, but whether or not their evaluation adheres to the terms of the solicitation and the procurement regulations themselves. So it is definitely quite a substantial protest ground. I think we're going to start talking a little bit about the protest grounds specifically with respect to the technical proposals that are most commonly seen. A lot of that is going to be challenging the assessment or failure to assess specific strengths and weaknesses. Another example of a challenge to an agency's technical evaluation would be with respect to key personnel. You will often see solicitations that require key personnel that are listed and to be proposed. Maybe key personnel is not actually qualified, and so you know this because you've looked at their LinkedIn information. You know this because the awardee hired that individual from you, and they used to be your former employee. There are a ton of different ways in which you can attack an agency's technical evaluation, but it's also important to not only use the information you know about the solicitation and the solicitation requirements, but to also try to leverage just general public market information in order to make your arguments and attack the agency's evaluations. An example of that, like I said, would be the key personnel. It could also be knowing whether or not your competitor, the awardee, has the required licensing or certifications that the solicitation requires. We have seen protests where the awardee did not have the required certifications, and that was publicly available knowledge. And so when the protester realized that the awardee didn't actually have the required certification, they filed a protest and were ultimately very successful with that protest and received the award.
Right. So good, an important takeaway I would imagine that is doing your research beforehand, and
Yes.
given the quick turnarounds, doing your research before the ultimate award decision is made, so that if you are unsuccessful, you will have that information ready to go, and you will be primed to know whether or not there's a potential challenge on that ground.
Exactly.
Yeah, and I think in that vein, utilizing publicly available information can help you under a challenge to the agency's evaluation of the awardee's past performance submissions as well. And there are a number of resources that could be used to obtain this information. So there's the Federal Procurement Data System, there's hiregov.com, there is govtribe.com, and all of these sources can allow you to obtain information on, for example, the value of the contract or the size of the contract. That could help you in a relevance challenge, for example, where the agency has found that the awardee's past performance submission met the relevant standards, but you, doing your research, doing your homework, have learned that actually might not be accurate, or there might be additional information that is missing. And so if you have that information at your disposal, that could be used to potentially wage a past performance challenge. And is there any other context there with regard to these resources that people should consider?
Yeah, absolutely. And while some of the resources that you mentioned are paywalled and require a subscription, FPDS is obviously a free resource that's available to anybody. You should also check contractor websites as well as any sort of PR releases. You will be surprised the amount of information that you can find just through publicly available information contacts on the internet. All of this could also be really helpful with respect to recency arguments in past performance. A lot of solicitations will require the past performance to be within a certain amount of time, within the past 3 years, within the past 5 years, and it is not uncommon for offerors to submit past performance experience that it falls outside of that recency scope, and so it's important to check those public resources and make sure that the agency's evaluation of past performance is accurate.
Absolutely. And just one brief final point on past performance in particular, obtaining that information is so important because under the past performance context, there's a particular doctrine that the GAO applies, which requires agencies to consider information that is considered, quote, too close at hand not to have been evaluated by the agency. And the gist there is that agencies can't ignore adverse past performance information that would be related to the contract at issue that they were aware of. So if you as the potential protester are aware of that information, you can then bring that forward for a potentially successful protest ground. So under this broader category of evaluation challenges, we've covered technical and now past performance. And the third, you could call it subcategory here, would be cost and price. So that can be a little technically confusing. So I'm going to defer to Rachael to tell us a little bit about some of the nuances there.
Absolutely. Well, I mean, I don't pretend to be an accountant. Math is not really my strong suit, but we will, in a very broad sense, a lot of the cost and price challenges are going to depend on the type of solicitation that you have and the evaluation that was required by that solicitation. For example, if you have a cost reimbursement contract, the agency is going to be required to do a cost realism analysis, and so then you have the option to challenge that cost realism analysis. Was it thorough enough? Was it reasonable? Did they adjust the price appropriately? If they did adjust the price, was the adjustment too much? Was it too little? There are a lot of different options when there is a cost realism requirement that will allow you to bring protest grounds. In the other hand, if you have a fixed price contract, your ability to make cost price protest challenges are going to be a little harder. Again, here unless the solicitation requires it, the agency is not going to be required to do a cost realism analysis, so that you can't challenge that they didn't do one. And so it does limit your ability to make those arguments. But occasionally, the solicitation requirements still have maybe not a cost realism analysis, but a cost reasonableness analysis that's required, or some further inquiry into the appropriateness of the offeror's pricing.
Yeah, absolutely. I know this subject in particular can be a little, technically complex with some of the similar and comparable terms, but I think one of the bottom lines would probably be that if the solicitation provides for a cost realism analysis, that is something that you want to pay attention to, and then sort of have your ears and eyes perked when you are reviewing the debriefing and agency explanation for their award. So we will end this category by reviewing some other related and common challenges that can be made, specific types of arguments that are recognized in the bid protest landscape. So one is an argument that the agency applied what would be known as unstated evaluation criteria, and as might seem pretty intuitive, the agency is required to base its evaluation solely on the solicitation factors, and it cannot go outside of those beyond what you will hear throughout this as a general reasonable standard. So it cannot go beyond that which reasonably would be expected by offerors. So if the agency seems to require something or assess a weakness for something that doesn't seem to actually be a requirement in the solicitation, that is something to pay attention to. That's certainly something that could be a ground for a protest. Another type of argument would be an unequal or disparate treatment argument, which is where sort of in broad global terms, the agency has treated two proposals differently under the same solicitation requirement. So an example there would be assigning a weakness for an omission that exists in one proposal, but not in another. Are there any other examples there that I might be missing, Rachel?
Yeah, absolutely. Agencies also often have multi-person evaluation teams. It's not uncommon for one evaluator to evaluate this offeror and another evaluator to evaluate that offeror, and so often there are times in which the evaluators are using differing definitions for the same evaluation criteria, and so it's important to look and compare how the agency evaluated your proposal under a specific solicitation requirement versus how they evaluated the awardee's proposal under the same one, to see if they're applying the same definition of the requirement.
Right. Oh, yeah, and then the last one under this category to just briefly touch on would be a challenge to the agency's flawed best value trade-off analysis. That is where if the solicitation calls for, which again is something to look out for in the solicitation, the agency is required to adequately support its trade-off determination. And one important note here is that a best value determination would require a cost-benefit analysis. So it would require the agency to actually explain why it felt that the particular trade-off was worth it. So that sort of rounds out that broad category of general evaluation challenges that are the most common forms of bid protest and that are seen a lot. We'll move on now to talk about maybe you could call a little more niche area or maybe less protested area, but still just as important. The area of challenging the agency, the manner in which the agency conducted discussions. And if you hear the term discussions, you might think you know exactly what that means. But in the bid protest, government contracting landscape, it means something very specific. So, Rachael, what is a discussion in other than this type of discussion that we're having right now?
So any sort of communication between the agency and an offeror after they have submitted a proposal is technically called an exchange. There are multiple types of exchanges. For our purpose, we are most interested in paying attention to clarifications and to discussions. And so the main difference between a clarification and a discussion is going to be, one, when they happen, and two, what is allowed to happen. So a clarification happens prior to the establishment of a competitive range, whereas a discussion happens after a competitive range has been established. Substantively, clarification is very, very limited in scope. It's not going to allow for any sort of substantive modification or change to a proposal outside of clarifying or correcting very obvious clerical mistakes that can be fixed just from the face of the document.
Okay.
So that's going to be really basic arithmetic errors, typos, that kind of thing. Whereas a discussion is going to allow for substantive changes and modifications to that proposal, presumably to make it better as a result of the identification of weaknesses or deficiencies by the agency. And so keeping that difference in mind is incredibly important, because the agency can have clarifications with anybody, with one offeror, with all of the offerors, it doesn't matter. But when an agency engages in discussions, it has to engage in discussions with everybody, and it has to be meaningful discussions.
And if discussions do take place pre-award as part of the procurement process, what are some sort of triggers or things that potential protesters could look out for a bid protest challenge based on a discussion?
Absolutely. So one, they're going to want to, with respect to any discussions that they engaged in with the agency, they're going to want to look at what weaknesses or deficiencies were identified by the agency in discussions, how they resolved that or modified their proposal to address those weaknesses or deficiencies, and then whether or not the agency still continued to assess that weakness or deficiency. If they did, that is a very good sign that either the agency didn't take that additional information or modification into consideration, or there was just some sort of oversight on their part. That is not always a totally successful argument, because the agency could have considered it and just decided that it still didn't respond to that deficiency or weakness sufficiently. But that is a telltale sign that there might be something fishy going on.
And you would want to follow up on that.
Yeah. You should call your attorney at that point.
Call your attorney, yes. And we're not just saying that for obvious reasons.
Another example would be if the agency engaged in clarifications with an offeror, and then in response, that offeror substantively modified their proposal as a result. And it doesn't, in that case, it doesn't really matter what the agency's intentions were. Is if they accept that modified proposal, then that turns the clarification into a discussion, at which point they should have engaged in discussions with everybody else as well.
So be wary of clarifications that are actually discussions.
Exactly.
Okay.
Yeah.
So we'll move on to the third category of bid protest arguments that we wanted to touch on today, and those are organizational conflicts of interest, which we refer to as OCIs for their acronym. Generally speaking, an OCI is where a potential contractor has a relationship with a procuring government agency that in some capacity might taint the integrity of the procurement process or the contracted work. And I think that the most important takeaway from these types of bid protest arguments is that there are three specific types of OCIs that are recognized by the reviewing courts as potential grounds for sustaining a bid protest. So the first one is an unequal access to information. The second one is impaired objectivity. And the third is biased ground rules. So we'll just go through each one really briefly to give everyone an idea of what those are and what sort of facts and circumstances to look out for. So, Rachel, what's an unequal access to information OCI?
Exactly what it sounds like.
Okay.
It is where a contractor
Easy enough.
obtains information not publicly available that gives them some sort of competitive advantage. So that can look like the government accidentally providing proprietary information to the contractor of one of the other offerors. Occasionally that happens when an agency is attempting to engage in clarifications or discussions, or it can also happen when the agency fails to reasonably consider whether awardees' work on a management task order could somehow give them an unfair competitive advantage and information regarding a engineering support task order that they're currently bidding on. It is a very fact-dependent inquiry, but essentially it's just when a contractor has information that they're not supposed to, and it gives them a competitive advantage.
Understood. So briefly touching on an impaired objectivity, OCI, that is one where a contractor's work on one contract might include something like evaluating itself or a connected entity in a manner which would undermine or could undermine the contractor's ability to provide impartial advice to the government. And you could see how that would create a conflict of interest. An example would be a contractor evaluating their own regulatory compliance or evaluating its own or a competitor's offers, products, or services. You can see without too much additional explanation why that would create a problem and be a ground for a challenge. So if there is information like that out there, that would be something you would want to raise in a bid protest. The third is biased ground rules.
And that, again, is pretty straightforward. It's going to be where a contractor in some capacity has set the ground rules for a particular procurement in which they're not allowed to participate anymore. So if a contractor, as part of a different contract, is drafting a statements of work or a solicitation or performance work requirements, anything like that, then they are not allowed to perform on the contract that is actually performing that solicitation work.
Understood.
Yeah.
Okay. So yeah, those are just quick overviews of the types of OCIs that would be recognized by courts that you will want to look out for if you do have some sort of information at hand for a potential protest. And with that, we'll move on now to the fourth and final overall or broader category of protest argument, which, if you're still with us, we hope you are, is a very important one, so we want you to perk up. That is inadequate documentation of the agency's evaluation decision. And as you might be able to guess from that description, it is exactly how it sounds. It would be a challenge to the agency's failure to present sufficient documentation in its evaluation materials that would support or provide a reasonable basis for its award decision. And because of this requirement, if the agency doesn't have that sufficient evaluation, that in and of itself could be a sufficient basis for the GAO deciding to sustain a protest. So tell us a little bit more about these, Rachel, and why they are so important.
Yeah, absolutely. So they're mainly important with respect to filing your initial protest. As most government contractors have experienced, the amount of evaluation information that is shared after an award by the agency can vary greatly. If you're in the DoD space with enhanced debriefing, you are going to get a much more comprehensive information with respect to why you were unsuccessful or why you were successful. If you are in a non-DoD space, you're going to get a debriefing if it is required under Part 15, or you're going to get a brief explanation. And sometimes those brief explanations and debriefings can be incredibly brief. Pun intended.
It's a debriefing. It's not a full briefing.
Yes.
That's my one dad joke for this podcast. We'll refrain from those.
Yeah, it is not abnormal for the government in response to a debriefing to simply refer back to the solicitation requirements instead of actually providing a substantive answer. And so what you're left with is very little information about what actually happened. And so you're kind of stuck in a position where you think something fishy might have happened, but you don't really know because you don't have an answer. And so that's when you're going to rely on this protest ground. And it really can be helpful in getting over that motion to dismiss hump so that you can get an agency report and you can get a much more comprehensive rundown of the evaluation that happened to file a supplemental protest, or to sometimes to even see that the agency actually did do their job and there aren't any sufficient protest grounds to continue with.
Right. But if you think you do have a reasonable basis for such a protest ground, it's important to raise that, right? Because you can find yourself in a situation where you've waived the argument. So,
absolutely.
Basically use it or lose it. If, you don't make the argument at the time and it turns out that there was some validity to it, too bad, so sad, then you won't be able to. And conversely, if you do advance the argument and then you get the agency record and it turns out that there is that adequate documentation, then you are, able to withdraw the protest at that time. So there are other considerations to take that are beyond the scope of this podcast and are specific, to the facts at hand and your, particular procurement and business interests. But generally, that's, the major takeaway under that category. So we've covered a lot of ground here, Rachel, in a pretty short amount of time. That wraps up this discussion today. Thank you so much for joining this real-world GovCon law discussion. If you have any additional questions, please feel free to reach out. And again, we thank you so much for joining us.
Thanks.